Thank you, Your Honor. May it please the Court. My name is Patrice Boyce. I represent Alachua Land Investors, LLC, which is the owner and developer of the Blues Creek subdivision in Alachua County, Florida. I'll refer to that as Blues Creek for these proceedings. I'd like to reserve 5 minutes for rebuttal if possible. My client is the appellant today. We're here on second-tier certiorari review. Our standard of review today is whether the circuit court applied due process in the proceedings below and applied the correct law. That's a well-settled principle of clear law that comes from the Supreme Court decision in the Broward County v. GBV international case. The case was decided in 2001. The issue before the court, as concisely stated today, is whether the circuit court, in the absence of any oral or written findings or reasons or really any explanation by the city commission, in fact in the presence of silence, as the court order stated, was authorized to come through the cold record to establish its own factual bases to sustain the city's denial of petitioner's plat.
Well, what else is a reviewing court to do when it's faced with no factual findings and an obligation to determine whether competent and substantial evidence supports the decision other than come through the record?
The state of the law currently, Your Honor, would dictate that the court remand, grant the writ, and remand act.
What case tells us that?
The cases that tell us that the court may not substitute its findings or
that's not the point. The point is you're saying that we cannot comb the record for CSE if there are no findings of fact. That was your assertion.
Yes.
What case says we're mandated to remand the case in that event?
The settled law, the procedure of certiorari.
Doesn't GBV say
How about with the
exactly
case?
the opposite?
GBV says the opposite.
Exactly the
I
opposite.
want to know what case it specifically says what Judge Randall gave. And I'll tell you that I understand your arguments that would be better if there were factual findings. But what case mandates that a city commission or a city or county making a quasi-judicial decision is required to have factual findings?
I believe that the question alludes to the previous decision reached in GBV, alluding back to Snyder and some of those discussions in the bar and the academic community. And I believe those holdings were very, very narrowly prescribed in the question certified to the Supreme Court on the question of written factual findings. If we look at Judge Zemmer's opinion, which
We
is
look
not
at
law,
GBV counsel, which is, believe me, I think a lot of people would have some empathy for what happened to your client. That's really not the issue. You've got a city commission that votes for God knows what reason and denies an application that you all think is perfectly reasonable. You know, reasonable minds can differ about that. If you look at GBV procedurally, it's not exactly the same as your case, but what is similar is that at the end, the Supreme Court ends up saying, well, you know, the circuit judge erred here because he or she did not simply look to see whether evidence supported the ruling of the governmental body. Isn't that exactly what we have here?
No, Your Honor. In our case, the circuit court looked to evidence that was not identified as evidence.
Ma'am, that is exactly what happened in GBV. Tell me I'm wrong.
The evidence.
The commission in GBV, the Broward County Commission, voted, made no findings at all.
Your Honor, with all due respect, the circuit court in GBV looked to evidence that was presented at the hearing below and made its own findings. In our situation, the circuit court looked in the record, the cold record, and picked out facts that were not presented at hearing and adduced and identified as evidence.
Wait.
Specifically,
What is the record that the circuit court is allowed to look at?
the record that the circuit court allowed to look at, Your Honor, is our position in the cases would support that it is the evidence adduced at hearing, identified, and introduced as such.
Okay. You need to
The
help
court is not-
because I'm familiar with how city commission meetings work.
The court is not.
You know, I've always felt, and correct me if I'm wrong, the record from the zoning and planning board, staff recommendations, all those, even though we did not formally go to the city commission and say, we'd like to introduce this as exhibit number 1, that is all evidence that the city commission or the city governing body, or I should say this local government entity making the final decision is entitled to rely on in making their decision. Tell me if I'm wrong.
The city commission's entitled to rely on?
Yeah.
That would be correct if the city commission identifies that as its basis or reason or explanation.
Okay, but that goes back to the question that Judge Van Nort asked you originally.
The problem is here, the circuit court doesn't know what the city commission may or may not have relied on, and instead of speculating. And
But isn't that the case in every case, unless there is a requirement that the quasi-judicial body make factual findings?
in writing, no. Sometimes in jurisdictions, we
I understand that you're saying in writing, but I'm saying anywhere, either as part of their motion, or either the oral part of their motion, or writing. Is there a case that says there has to be the findings? I go along with Judge Khan.
Well,
I have a lot of sympathy for your client.
Oh.
Because I've represented both developers and cities, and I wanted to always know when I was on the development side, why are they doing what they're doing, and is there evidence to support it? I have empathy for that, but give me a case that says that.
we have to track back to the due process requirements that are recited and relied on in the Irvine case, Gentry, Laney, Lynch Davidson, Powell, Brevard County v. Snyder even, as encapsulated in Judge Zamer's opinion, which is now long and echoed in the Perriente dissent, which I realize is not controlling. Also in the commentators, which have been cited by both sides, the Devenau opinion, or excuse me, the Devenau article and the Pelham article that the parties have cited. Due process is really where this emanates from. There's a thread that's run through all these cases for 30 or 40 years. We look at the Administrative Procedures Act, we look at the line of administrative law cases that say courts, it's not only the Administrative Procedures Act, it's also the due process.
Act specifically say it is not applicable to city and county government.
I was about to say that it's not only the Administrative Procedures Act, it's also rooted in the due process requirements. Yes, you're correct, Your Honor. In this setting, those principles have been applied to cities and counties as well. Due process mandates that an applicant for a permit to use his land understand why he's not allowed to use his land. Zoning laws, land use, permit type laws are in derogation of private property rights.
This is it's not a taking case or something like that. We're bound by the standards of the Supreme Court second-tier cert. Is it your position that no competent substantial evidence exists in the proceedings before the local government that would support denial of your plat application?
With all due respect, Your Honor, the competent substantial evidence problem is not even
With all due respect,
a part
I
of
want
this
you to answer that
inquiry.
question, yes or no.
That no
Is it
competent
your position that there's no competent substantial evidence in the record developed before the local government that would support denial of your plat?
Our position is that there is no competent substantial evidence to support denial. There is competent substantial evidence to support approval. We don't
Okay, so let
know.
me be clear. Your position is that there is no competent, that if the judge combed through the record, which they're not supposed to do, there would be no CSE to support denial of your plat, not any, not zero, not sure.
If we look at the requirements for plat approval under the GBD case, the burden shifting, you have to, it's not like a rezoning case where you have to prove an entitlement to the land use or a change of zoning. This is more like a special exception that carries with it a presumption of legislative entitlement. If you come forward with a burden of showing that you've met the objective legal standards, which are supposed to be readily discernible by the average applicant, in our city code, it's section 30-183, sections A through E, it's like a checklist, very similar to section 177 in the Florida statutes. If you meet those on prima facie,
I understand your argument. It's the only case in front of us, the Board of County Commissioners versus Snyder.
GBV.
Yeah, but after that, you have GBV.
Right.
It's not a rezoning case.
Well, I'm arguing that based on our GBV, we need the checklist.
But
Burden and
counsel, that's
shifts.
why I asked you, and I'm not as knowledgeable about this as either you or my colleague, but I do know what the remand was in GBV, and that was remanded back to the circuit court in Broward County to determine whether any competent substantial evidence supported the local government's action.
In direct answer to your question, there is no competent substantial evidence to show to support a denial under subsections A through E of our prima facie showing. Absolutely, that is our position. Now, that is the objective legal criteria, and that's what we have to show. That is our burden of coming forward. When the burden shifts to the city under subsection G, where it's the subjective, do you meet the plans, policies, goals, the compatibility, all those things that we really can't get our hands on. It's a general policy check to make sure you're not putting, an obnoxious use next to a school. Those are less discernible. They're more objective. They are not the objective legal criteria GBV talks about. Yeah, there the burden is on the city to come forward and show CSD that they have to make an affirmative showing that we offend or are adverse to the public interest. There was no such showing in the evidence.
Yeah, I understand that. You didn't challenge the ordinance?
No, and we're not. We're saying under that, the ordinance as applied to us, that's how the order of proof went, and there was no competent substantial evidence as the burden shifted on our prima facie showing, and as the burden properly should have shifted. And I might add, the circuit court kept the burden on the applicant the entire time, and that was another application of incorrect law. I didn't get to proceed through my argument, but
Okay, you're down to 3.5 minutes. And stop the clock, Mr. Clerk. We gave it into a seminar last night, and one of the things we said, if you just came up with a remark, was it's not for you to get it through your argument, it's for us to find information that we want.
absolutely,
Just for the future.
absolutely.
Okay, okay, you may proceed. If you want to proceed further, you can take 3 minutes and 20 seconds.
I'd rather stay for 3 minutes. The only thing I wanted to emphasize is we do feel these legal errors in the circuit court do rise and meet the second prong on circuit tier of being a serious miscarriage of justice because of the due process element we discussed here a moment ago. This will chill future applicants in seeking judicial review of quasi-judicial decisions. It in effect insulates silent orders from any kind of review, and you in effect convert quasi-judicial decisions into deferential legislative review decisions. Thank you.
May it please the court. My name is Daniel Nee. I represent the city of Gainesville. The city, of course, respectfully requests this court affirm the first tier judicial decision of the Circuit Court of the 8th Judicial Circuit below, which upheld the quasi-judicial decision of the Gainesville City Commission.
You know, we jumped all over your opposing counsel, so we may as well jump all over you and start all this way.
Sure.
If I have to understand their argument, that in a case like Schneider, where you're basically talking about a legislative decision rezoning, where the city has a lot of leeway, in those kind of cases, you shouldn't be required to have factual findings. However, when you get to decisions like facts, special exceptions, where the city does not have as much discretion, where you're really talking about whether an applicant meets the requirements of those particular sections, shouldn't an applicant have to be told, or shouldn't the city be required to really come up with the reasons why they're rejecting that application?
Well, what was pointed out by this panel is that we do have, when we talk about whether or not the findings should be required or not, what we do have is the guidance of GPV of the Florida Supreme Court directly applying Snyder to a HUD application case and saying that, and discussing that at length with a great deal of concern as to whether or not the policy determinations make it appropriate or not, and they come down to the decision that they should not be required. Now,
Okay, well, let me go down. This, in an ordinance like the city of Gainesville, where you have very specific requirements, and then you have that catch-all category that a lot of ordinances have. It's not in the best interest of the city or whatever, you know, that kind of language, most ordinances have that. If the city is going to rely on that catch-all phrase, shouldn't they be required to then come up with a reason why they're turning an application down?
and is that the best practice? Would that be the most desirable from the point of a litigator? I think absolutely. But the question is whether it is required, and the policy behind whether it should be required is what was discussed at length with GBB, and what...
Is there room in the GBB decision to say when you're relying on that catch-all category, in those limited circumstances, then the city has to tell the reason why they're denying the application? You understand my question?
Respectfully, no. I think what GBB and the preceding cases, Belongs and Snyder and Dussault tell us is that just as the GBB court, the Supreme Court, sent it back to the circuit court to review the record to find competent substantial evidence, is that the decision is what must be supported by competent substantial evidence. In the briefs filed by the appellant, there seems to be at some point an argument made that what must be supported by competent substantial evidence is our findings. And then Belong even talks about how the administrative findings and decision must be supported by competent substantial evidence. What we've seen in the cases from that, the Supreme Court cases from that, is the focus is on whether the quasi-judicial board, the board below's decision, its ruling, was based on competent substantial evidence.
Okay, in this case, is the competent substantial evidence to demonstrate a specific portion of the ordinance that the people violate, or are you relying on the competent substantial evidence to support the catch-all at the end?
There are criteria to go forward with the plat application that must be met by the applicant. And what I think Judge Smith of the 8th Judicial Circuit looked at in proposing his order, and he was very cognizant, very empathetic, just as this panel may be, with the arguments in favor of requiring written findings, but understanding that the state of the law didn't require that.
But didn't Judge Smith then, this is a weird thing that's emanated out of these cases. It seems like Judge Smith is a good judge and took a very close look at this, but didn't he find himself in a position of having to do exactly what the cases tell the circuit judge he's not supposed to do, which is to carefully review the record and sort of make his own findings? Isn't that what he did?
No, that's what he was concerned about, and he voiced concern that this sort of review of a record treads dangerously close. There's a temptation for a court to review the record when it's directed to review, to make findings when it reviews the record. But then, after carefully analyzing that law, after carefully quoting from Justice Cariente's dissent, after being fully aware of the pros and cons and the fact that this is a concern, the requirement of written findings, that has not only been discussed by the Supreme Court, that's been referred before the bar, that's been referred to committees before the bar.
Well, I noticed a lot of discussion about that. I completely discount that. I served on that rules committee for years and years and years. We never took that up because Florida Bar Rules of Judicial Administration can't direct city government what to do, and the Supreme Court should have done that when they put that sentence. So that's what I'm asking you is more fundamental. We've got cases out there before and after GBB saying the circuit court errs on first-tier cert review when the circuit court conducts an independent review of the record. Yet it seems, one might argue, that's exactly what the circuit court is forced to do in the situation Judge Smith found himself.
I think I agree with in part, what the circuit court did was, as directed in GBB, reviewed the record, and then he was very aware of the dangerous missteps that might be available to a circuit court. And that's why he mentions that respondent, the city of that case, has provided this court with a starting point by citing to some evidence in the record which supports.
But you would admit, you as the respondent in both of these courts would admit that you might, as a good lawyer, a good local government lawyer, come up with 4 or 5 bullet points of evidence that, as far as we know, the city commission never even considered. That's a possibility, isn't it?
Well, I admit that I try to do my job as best I can, but
But that's that's a
to be
very
fair-
real
But
possibility.
to be fair, there was nothing that
No, wait,
that was
I wanna
directed
know-
to the
I
circuit
wanna know
court
what
that was not in the record.
I understand, but isn't it a very real possibility that you might find things in the record, something some obscure planner said back in some office at some point, that the commission may not be considering?
Well, it would have had to have been on the record. It would have had to have been presented to that commission. There were lengthy hearings. There are transcripts of these hearings. They were part of the record below to Judge Smith. He did review them, 4 volumes, I think, of a record. It was extensive, and he did do a thorough job.
Let me tell you my other concern, and I don't know where this case will come down. My other concern is that it seems like following Snyder and GBV, local government is free to make a purely political decision based on considerations completely extraneous to the merits of the land use application. Purely political consideration by, let's say, county heads at the commission meeting. And then say, you lawyers just take care of this. Go over across the street to the circuit court there in Alachua County and find some evidence to support it, because there's no downside to the commission doing it.
I would disagree, because I think that is part of the circuit court's determination in determining whether the evidence produced as part of the record is competent and substantial. If the lower cross-judicial board is just going to count heads or is going to act on some sort of insidious motive, then the circuit court, hopefully by review of the record, by guidance of counsel on both sides on a circuit review of the circuit court, which to review, can look at that evidence and say that is not
That's
competent
exactly my
evidence.
point, though, is that there's no, I don't see, given your scenario, I don't see the deterrent to it, and we're not imputing any city as flows. I don't know who was on the city commission. But there's no downside to the city commission making simply a political decision and then taking a wait-and-see attitude. If it comes back, they make another decision. If it doesn't come back, their decision stands. Is that really the way we want to deal with property rights?
I don't think that's the way we want to deal with property rights, but I don't think that that is the danger that presents itself in this case, and I'm not sure if that's a danger that presents itself on a regular basis or not some sort of creative worlds.
Well, let me throw something out. I mean, just because, wouldn't a city, if they're acting totally arbitrarily and denying property rights, be subject to federal civil rights action?
Absolutely.
Okay, so that's the only check that you arguably would have.
I wouldn't say it's the only check, but it is a serious check, and that's, again, part of trying to do my job, is trying to also make sure our city commission understands its responsibilities, and to not just make political decisions, but to make decisions that apply the criteria in the code, apply them fairly, apply them with due process. There was no argument below that the due process wasn't afforded, and that make the decisions based upon the competent substantial evidence before it. And that's when it gets to the circuit court's going to evaluate that competent substantial evidence in line with Millant and Snyder and GBV. And to require there to be detailed findings, and I don't want to go too far into the policy determinations that were examined by the Supreme Court, that were gotten into by Justice Periante in her concurring opinion in Dussault, her dissenting opinion in GBV, and by Chief Justice Wells in his concurring opinion in GBV. It is a matter of great impracticality to require a board, a quasi-judicial board of the city, to enter these detailed findings of fact. And they get into all those policy determinations, and that's not relevant here necessarily, except to the point that this is an issue that was given a great deal of analysis and a great deal of thought at the Supreme Court level. And the current state of the law is to not require detailed written findings for decisions such as this, specifically plat applications decisions for GBV. And it's certainly what was done here by the circuit court, by Judge Smith at the Eighth Circuit, did apply the correct law.
What was the evidence that Judge Smith found that it constituted sufficient cause to deny the plat application?
To quote from page 7 of Judge Smith's order, the design plat application and Loose Creek master plan are inconsistent in this regard and therefore constitute competent substantial evidence that the applicant failed to demonstrate compliance with existing, quote, existing zoning requirements, including amendments thereto, unquote, as well as, quote, policies and plans established by the city, unquote, in regard to the future development on this site. There may be other items of evidence supporting the city's denial. However, this court declines to dig itself farther into the trap of potentially reweighing the evidence.
So he recognized the quandary that he was in. He did have to sort of peek to find the answer, but he didn't want to peek too much.
I don't think he had to peek. I think what he did was, he looked at the record as directed by the controlling case law, found substantial evidence supporting the decision of the board, and then stopped. Because he realized this is a treacherous area, and that do we all agree that maybe it might get better? It might be an easier practice, I would say, certainly for reviewing courts, and certainly for litigation attorneys, certainly for appellate attorneys, to have written findings. Well, absolutely.
Are you prepared to recite today additional, as I'm sure you were at the time of the circuit court here, are you prepared to recite additional record evidence that would have supported the commission's action? Would you rather?
It was in detail. I think there were 18 or 16 criteria that were argued back and forth by the petitioner and the city at the circuit court level that were briefed extensively at the circuit court level. At that point, there were no arguments that that decision wasn't based on findings. The question was that the appellant now didn't feel that the competent substantial evidence was competent substantial evidence. They felt it was not, did not rise to that level. Words in the mouth, that was my understanding of the argument. And there were, I think, 16 criteria. And there were criteria that were originally presented, as discussed by the panel, by the planning staff, and formally presented to the city commission in its quasi-judicial hearing as part of the recommendation to not approve the plat application. And that there was ample opportunity and a great deal of hearing at the quasi-judicial board, the city commission below, on those criteria. The one main one picked out by the court, probably the biggest one, is the fact that it didn't meet the zoning requirements to go forward. That the master plan sort of defining the zoning of the area, and the plat application evidence was presented at the hearing and accepted by the circuit court that that the plat application would violate that zoning laid forth in the master plan. And again, and what the circuit court did not do is rewrite the evidence.
Is it your commission's policy not to issue findings on quasi-judicial decisions?
Well, interestingly enough, this didn't come up below. I mentioned it sort of as an aside in our brief to this court, is that if a formal quasi-judicial hearing is requested, the rules of our commission provide for a formal or informal hearing. If a formal hearing is requested, it was not in this case, then a written order is produced. In this case, the formal hearing was not requested.
Formal hearing being there need to be conducted by hearing officers?
No, it's conducted still by the city commission, but it's lengthier. Everyone is sworn in. More detailed records are kept. It is just more formal, and it does result in a written order.
Okay, and that was available to the applicant as part of the plat process here?
Absolutely right. Again, I see my time is up. It does seem that the panel is amply familiar with all the cases I was going to cite, and by any event, they were, I think, fully briefed for the court. The city would just, once again, respectfully submit that the court should deny the second derivative cert, affirming the order of the circuit court that denied the application below the quasi-judicial court. Thank you for your consideration. Thank you for the opportunity to hear the court.
Okay, the question that comes to mind immediately, and I'm not going to stand there without asking questions, is if the city of Gainesville has a requirement or the ability for an applicant to request a formal administrative hearing, the question of whether findings of fact are issued, hasn't that issue been waived?
It's a distinction without a difference because they're both quasi-judicial. They both put you into the certiorari judicial relief forum. You don't waive the right to due process in either case.
It's not a question of denial of due process, but if you want formal findings of fact, if you want formal evidence, that is available to you as part of the city of Gainesville process. And I understand from a developer standpoint, politically, you might not want to do that. You might not want to do city council, but if that is available to you and you do not take that avenue, why haven't you waived it?
We're not requesting written formal findings of fact in our briefs. We're here today. We're suggesting and asking for explanation, reasons. You can't give just an order. The written order coming out of the formal quasi-judicial hearing could very simply have been denied. There's no explanation, no findings either. It could have just as easily been as error. And we would still be here today with the same petition.
But we at least have the argument under the city of Gainesville process, since they adopted this formal procedure, they were required in that circumstance to have factual findings.
We go back to the choice you made, you're correct that it is a political one, with the applicant not wishing to offend the city commission because they do bristle when you bring forward a formal process, because plats typically are ministerial, they're usually on the consent agenda in most jurisdictions. They typically take very little time and don't call for a very formal adversarial proceeding. They usually are not controversial. So that weighs into it as well. I wanted to address the...
Okay, Counsel, are you really asking us to maybe certify a question to the Supreme Court to see if given their very different makeup now than at the time of GBV, that they might reconsider Justice Perriente's dissent? Is that really what you're asking? Because you can't really be asking us to disagree with the Supreme Court.
I think Judge Smith is, very definitely, in the structure of his order. I can't honestly say that we've asked you to do that in our briefs. Now, here today, that is the procedural vehicle available to you, and we'd be happy to supplement the record with a proposed certified question if that's the court's will. Certainly, that would be appropriate and would forestall future miscarriage of justice. Quasi-judicial permits, such as plats, would be a good place to start. They are fairly pure in their quasi-judicial sense. They are recognizable. You can get your arms around the legal objective standards that GBV talks about. But I wanted to address briefly the evidence in response...
Very briefly, because your time is running.
Thank you. In response to Judge Kahn's question, the evidence that was not in the record presented to the City Commission that Judge Smith cited to you in his order on page 7 was the 50-foot construction buffer requirement. That was mentioned in the order. That played into his ultimate finding that we were inconsistent.
Is that not contained in any portion of the record made by during the hearing process?
He had to do a de novo review of the application to come to that.
Okay, but it was available either as part of the application or as part of the hearing process that took place in front of the various other city boards.
We could not discern a bright line in the cases, to be candid, as to whether the application is part of the record or not, unless it's introduced formally as evidence, Your Honor.
Again, that goes back, if you do not request a formal hearing, having you weigh the fact that things are not formally introduced as evidence in the city council.
I introduced everything into evidence at the informal hearing anyway. I make that a practice, so
I
everything...
understand you do, but for the city to be on notice, when they have a procedure for a formal hearing, shouldn't you be required to ask for it?
No, well, that's the city's prerogative. We don't control their procedures. But as for the application, it's in the packet before the city commission. I've had city attorneys tell me, and this one in particular, if you don't label that and move it into evidence, it's not in evidence. The rules are all different all over the state. And like I said, in all candor, there is no bright line, and practitioners need guidance.
Thank you, your time is running.
Thank you.
Take a 15-minute recess to a few minutes after.